Yo, we are literally having a fucking law class here. Like the goddamn video. Y'all are not going to get this kind of content anywhere else. Someone actually reading legal documents with you guys and breaking it down. What the hell is going on here? Okay? I'm taking this crazy ass English and bringing it to real English for y'all. So let's pull this up real fast because I'm learning as well because I didn't hear about this case before. But let's pull this bad boy up. Let's see here. Was this it? Yeah. Okay. So, right, because in law enforcement, guys, they teach you like basic cases, like they teach you like the main ones, like Tennessee versus Garner. They teach you a lot of use of force ones. This is like more lawyer shit. Okay. But yeah, let's get this here. U.S. versus Fields. American Psychology Association. Okay. Let's see here. Sentence opposed to a defendant. Expert witness psychologist to competency. Is that correct? No, that can't be right. Let's look at another one. Oh yeah, this one. Okay. Okay, Petitioner Edward Fields pleaded guilty in federal court to 2 counts of first-degree murder, 2 counts of using a firearm during a federal crime of violence causing the death of a person, and 2 counts of assimilative crime. Fields was sentenced by jury to death on each of the 2 murder convictions and significant terms of imprisonment on each of the remaining convictions. After completing the direct appeal process, Fields initiated proceedings before the 10th Circuit Court of Appeals by filing a motion to vacate, set aside, or correct a sentence pursuant to 28 U.S.C. 2255. The district court denied Fields' petition and also denied him a certificate of appealability. After its review, the 10th court reversed in part the district court with directions to conduct in it. Okay, so let's see here. So they reversed in part and remanded to the district court with direction to conduct an evidentiary hearing on Fields' claim that his trial counsel was ineffective for failing to adequately investigate and present at trial evidence of his organic brain damage. Okay, so to me, it looks like something that is out of their control. Okay, so they basically hit him on something that was a little bit out of his control. So because what he's saying here, okay, this might be a reach by his defense, but let's see here. Okay, so there was nothing to intervene the physical restraint of them. So there was nothing they can do, essentially, which is kind of like that guy having his brain damage. There was nothing that he can do. Okay, that's how it seems interpreted to me. If we got any lawyers in the chat, let me know if I'm correct there. The defendant Fields was a passenger in a vehicle parked in a driveway of a house. He sought to suppress several firearms that were found under the house. The government argued that Fields lacked the Fourth Amendment standing to contest the search. Oh, okay, so this is a fucking another case. What the fuck is this shit then? Okay, let's read this then. Okay, to contest the search under the house because Fields lacked the reasonable expectation of privacy as to the house. The court did not decide that issue. Instead, the court applied the established rule that a passenger in a vehicle that is stopped by police officers is seized within the meaning of the Fourth Amendment. Therefore, Fields had standing to contest the seizure and the firearms as fruit of that seizure. The court held that Fields was unconstitutionally seized and the firearms must be suppressed as fruits of the unconstitutional seizure. Okay, all right, I get it now. All right. Golden relies on footnote 60 in Fields. It is not the case that the fruit of the poisonous tree doctrine applies only when the defendant has standing regarding both the violation which constitutes the poisonous tree and separate standing regarding the evidence which constitutes the fruit of the poisonous tree. Therefore, the Fields defendant could challenge the seizure of his person as a violation of his privacy interest, regardless of whether he could establish a property interest in the item he sought to suppress. Okay, that makes sense. That makes sense now. Basically, it was like going to be like, yo, they unlawfully detained me, right? They seized me, and as a byproduct of them seizing me unlawfully, they were able to seize the gun. Okay, which I'll give you guys an example of this. That's a little bit easier to understand. Let's say I have a police officer, right? Because the feds do this shit all the time. I know that a guy's traveling and he has drugs in the car, right? Like he has 5 kilos, right? We're watching him. And I'm going to get the state trooper to stop him. Here's the problem, though. The state trooper can't just stop him, put the lights on. Hey, asshole, I know you got drugs in the car. Get out. Can't do that. He's got to establish his own probable cause to stop the guy. So, He's going to wait until he doesn't, do a turn signal. Boom, he can stop him for that. He's going to wait until he speeds. Boom, he can stop him for that. He's going to look. Maybe he doesn't have a, he has like a fucking, what's the thing in the car that you put on the rear view window mirror?
Did you put on the rear view mirror?
Yeah, the thing that makes the car smell good.
Oh, air freshener.
Or air freshener, whatever. It obstructs his view. Like, or let's say he does all three of those things. Perfect. Now the trooper has probable cause to stop the vehicle, okay, and conduct a stop so that he can, try to get to the bottom of it and get to the drugs. Does that make sense? Now he has a real reason to stop him. So, and get the drugs. But let's say he just stopped him for nothing. Said, "Hey, you got drugs in the back." That seizure is going to be thrown out because he unlawfully detained the person first. He unlawfully seized the human, and then unlawfully seized the drug subsequently to that. Does that make sense, guys? So, so that's a little bit more of an easier example to understand. Okay, let's see here. Okay, so Fourth Amendment standing against the SD card media. The government argues that Golden Hat lacks a reasonable expectation of privacy as to the camera and SD cards because Ramsey owned those items. Okay, that's a good argument. Further, is Golden's burden to establish an expectation of privacy as to those items, and he presented no evidence on that point. Therefore, Golden lacks standing to suppress the camera and SD cards. But finding that Golden lacks standing to suppress the SD cards is not in the end of the inquiry. Although he cannot challenge the seizure of the cards themselves, he may have a constitutionally protected privacy interest in the contents of the SD cards and the SD card media. As to Golden's reported reasonable expectation of privacy in SD card media, the government pushes a two-pronged argument. First, Atlantic Records has a property interest in the media, so Golden cannot have a reasonable expectation of privacy to it. Damn, okay. And second, the media serves a commercial purpose, so it is entitled to less protection than personal property per the Supreme Court decision in Minnesota versus Carter. Okay, let's look at this case too. Bro, I'm learning myself here. That's a good argument.